so much for this opportunity, and thank you for all the speakers before me. I have been very privileged to have spent 7 years of my life in trafficking, so part of my heart is still there. I have prepared a very basic entry-level talk, and the reason for that is for our students to try and understand how we as practitioners do mediation in practice. Africa, it's not time to not have a litigation practice, because unfortunately, as you can see, there's highway speeding. We're not there yet. This is where we would like to be going. We've been in the mediation space for many years. I was in the 90s in trafficking as one of the directors at the Department of Safety and Security, and we mediated at that stage the taxi violence, the mine violence, and all the community hardships. With the advent of the democracy at that stage, we were faced with a lot of challenges in smoothing over that process. Another project I was involved with and championed from the office of the MEC at the time, who was Satish Ripa, was the amalgamation of the police force, the South African police force, and the Botswana police into SAPS, the police service. And we had to sit endlessly in meetings and smoothing over all sorts of difficulties. And we did that for 3 years. It was quite a challenging process, but it was most rewarding from a professional perspective, because there's no ways you can learn that much unless you're confronted with those many disputes and areas of conflict. So conflict management has been my thing. I'm at the moment an attorney. I converted from an advocate in July of 2021 to become an attorney. And my mediation practice as a private mediator has been up and running for about 9 years. There are difficulties with mediation in finding it as a profession. So mediation in South Africa is nothing new, because we know what Ubuntu is. With the talks at CODESA, prior to us becoming a democracy, those people set the path for us as a nation to be incredibly good at dispute resolution. But should we take it at a personal level as attorneys, mediators, psychologists, acting as mediators and so on, it's quite difficult to introduce alternative dispute resolution into practices. And I think one of the biggest challenges is that the public do not see mediation as a value step in dispute resolution. People have been manipulated in thinking like litigation is superior to mediation. And because it's quite new at a personal level, because divorce matters are very personal, it can be seen as something that should not be valued to the extent like a high-profile lawyer in suits in the program, I'm fighting your case. Now, the reality in practice is the moment you have a litigant who wants to fight the case, they've got to have very deep pockets. And unfortunately, Lienke had shared her story and experience of attorneys wanting to fight for the sake of fighting and writing fees. And that is one of our main difficulties in establishing mediation in the practices of attorneys, because I think many of our colleagues feel that they will lose out on fees. And the reality is we've got overheads, we've got offices to pay, and the billing hours can be more profitable than mediation. I'm always saying to everybody that if there's a high conflict dispute, whether that's medical, legal, or commercial or family law, I prefer having the attorneys in that meeting. And what the message I want to send to counsel and attorneys is that you are most welcome in those meetings, because you take a load from my shoulders as the mediator. Mediation is not about rights, it's about interests. And that is actually a big topic for a next gathering, so that we can share those ideas. And Johanna has drafted a beautiful book on exactly what those interests are and the concerns and all the underlying stuff at that psychological level, because we are dealing with people. But let's park that for another date. What we have to understand is that we need the attorneys in mediation to safeguard the rights of their clients. The mediator is not there to safeguard the rights. However, we can be liable for under-settlement in RAF matters, because we serve on the pilot projects of the SAMLA Association for those projects, and in terms of medical legal dispute resolution. And you've got to know what the quantums are. And unless you've got counsel there, you run the risk of not serving the process, because counsel would be well informed in terms of case law, how, in terms of the quantification of that claim, how that should be dealt with. So please, mediators, if there are mediators, invite the attorneys in to do their job. But for us, in our industry, we've got to lay out a path, a profession in mediation. Now, in my young days, 30 plus years ago, I was in the public relations industry in Mafeking. And at that stage, I had a master's degree in nuclear medicine. But because I couldn't get work in nuclear medicine in Mafeking, there were no facilities and no positions available at the former Unibo, I had to explore other options, and I went into public relations within the corporate world. And I remember we had a grand function with a marquee there in, I think it's Voortrekkerstraat, used to be Voortrekkerstraat, that main road leading from Mafeking town to the Mabatu Sun, right down there. Now, that old historic building was IGI, and we've set up the marquee there, and the CEO from Joburg, from that corporation, called me the gin and tonic lady. Without realizing I'm educated, I've got a degree, and it's a new profession, because that was early 90s. So nobody knew about corporate communications, image building, corporate image building, and brands. I mean, this is 30 plus years ago. So it was very new. And we had to pioneer in South Africa that new profession. And today, everybody knows what a PR practitioner is and what corporate branding and so on is. So we've got hope to take mediation on that speedy road to a profession. And I think Rule 41A will facilitate the way, but we've got to embrace our colleagues who are not yet on board and explain to them and get them on board. So the International Mediation Institute defines mediation as negotiation facilitated by a trusted, neutral persona Now, why trusted, why neutral? And again, let's park that idea for another discussion. My point I would like to make is it's not that simple. You don't only have to be trusted and neutral. Mediation utilizes very specific expertise because mediation is built on knowledge, and you've got two types of knowledge. We've got subject knowledge, and we've got mediation theory and mediation negotiation strategies. And unless you know the mediation theory and negotiation strategies and how to break deadlock and the theoretical aspects, you won't be able to mediate. But then, as important would be the fact that we also need a lot of skills. So in mediation, there are two legs. We've got a knowledge leg and a skills leg. Now, how mediation is practiced in South Africa, we've got practice standards. And these are the authorities who will be looking at the standard of practice to oversee that the knowledge component and the skills component in terms of training of mediators will be complied with. In terms of the family disputes and the divorce matters, NAPFAM is the national standard. And in terms of the commercial matters, workplace and medico-legal, it will be the DISAC standard. And please do Google their websites for further information as to how they function, who they are, and what those standards are. It's all listed on their websites. So in addition to these two regulators, and unfortunately they are regulators without actual teeth because there's no enabling act for mediation other than what we've got in terms of the mediation and the court annexed and so on. But nothing of that is really regulating the industry at the moment. So there are associations, and I did not list all of them. I've only listed the ones I've been involved with, which is SAM, the South African Association of Mediators, and Johan is one of the EXCO members. I'm a former EXCO member, and they've got a pilot project in Benoni where student mediators, and those are students of all ages and from various occupational backgrounds, mediate matters at the court within their guidelines to enable people to gain experience in the family mediation setup. It's skills training. The same with the SAMLA project. Now, the SAMLA project is not people of various diverse industries. It's in the medico-legal field, and there are two pilot projects. The one is the one for the Road Accident Fund, and the other one is for the Premier of Gauteng Province. And that one focuses on medical malpractice at state hospitals. Then we are all service providers. Service providers as mediators and as trainers, as coaches, and as assessors. So there's a lot of people, different organizations, private and other organizations in terms of NGOs and so on, who provides those services, and then the regulators of the standards. Now, mediation is a profession. And if I take you back to the second slide, you will see mediation. See, that was the time they thought I'm a gin and tonic lady, which I'm not. And we will change mediation, put it on the map as a profession. That's what we're working at. Because it's so complex, it's the art of mediation. It's not only a science. It's not only law. There's a lot of art in terms of the skills set required to be an effective mediator. We cannot mediate any dispute unless we've got a proper skills set to do so. Especially high conflict matter. If people start shouting at each other and they want to strangle each other and they don't get along about anything, and they're close to you, they're sitting next to you, and it's a shouting session, you've got to have the skills to bring those people under control. So what I'm saying, we are starting the journey. At this stage, it's a slow journey. We've been on the path for many years. We want to help other mediators and bring them up, and give them a helping hand to pull them up into the profession called mediation. And Africa for You, that day will come. We will have dedicated mediation practices, not a division within a law firm or a psychology practice or whatever. So the art of mediation, the best way to know what that standard should be, in addition to what I've already mentioned about NAPFAN and DISAC, would be to look at the IMI, which is the International Mediation Institute. And please do go onto their website, because now that's why we're saying it's art. We've got to understand emotional intelligence, intercultural conversations, that investor stakeholder engagement, because if you do deal with a complicated commercial matter, unless you've got expertise on the subject field dealing with, whether it is an insurance matter or a financial institute, financial matter, what it is, doesn't matter. There's sufficient insight in the subject field is required to unlock the dispute. Because as a mediator, we've got to generate options to create those flexible solutions. And obviously, the commercial interests. So I didn't realize when we were invited that Lynette will also be a presenter. You can see that this was my time still with Sam. Johan is there, I'm there, Lynette is there, and our other lovely colleagues. And Sam is still strong. There are many other people, and they do all sorts of webinars. Now we'd like people to encourage people who want to walk the walk for mediation to go onto all these websites, get and be known in the industry, and be known as part of these associations. Avail yourself to be on Exco. My dream for Sam at that stage, and I think I've spoken to Advocate about that years back, that we should have satellite branches all over South Africa to grow mediation. These can be located at universities or wherever, because unless, and there's so little going on in Northwest Province in terms of private practice in mediation, unless we make a concerted effort to build the profession, it's not going to happen. So I've already mentioned to you about the IMI. There's also a code of professional conduct and all the ethical considerations. Please do have a look at these organizations and DISAC. SAMLA I've mentioned to you in terms of the medico-legal field. We've got fantastic doctors who has trained as mediators. Because if there are allegations of medical malpractice, you need the skill set to be able to look into that dispute, to see whether Was it malpractice or not? So anybody with a bit of a medical law background will know it's not easy. And instead of spending 10 years to take it on to court, go through all those processes, and nobody's got the money to litigate for 10 years. So people don't have access to justice. That person who went to a public hospital and there was an incident and the family isn't sure. Was there malpractice? Did this person get the care in terms of the guidelines of their professional body or not? The best way to ventilate those disputes will be in a mediation. A child needing a wheelchair, why does that child have to wait for 12 years? By the time the lawyers are paid, you could have bought 1,000 wheelchairs. So it's totally nonsensical to deal with certain disputes in litigation. Then I've already mentioned to you there's a knowledge aspect, and the knowledge is subject knowledge as well as mediation knowledge and those strategies, and then obviously very many skills that we need as mediators. We need communication skills. We've got to be active listeners, because some mediations may last 8 hours. And it's not easy to sit in a chair for 8 hours and to keep people calm and to direct the process and to explore all the options and explore the underlying issues and so on. So I'm just listing these for your own reference, and hence making that submission. Mediation is also an art. If we are effective mediators, we will be able to demonstrate outstanding skills. And those outstanding skills will be assessed by a competent and accredited assessor. And that person will make a finding that within that 6 or 8 hours doesn't, you know, some of them, I remember the mine disputes, we would go to platinum mines, we will arrive at 4 in the afternoon. The next morning, 4 o'clock, we're still sitting in that boardroom and negotiating. So mediation can be a long process, and we can co-mediate to take some of the strain of the one mediator. When I do a long mediation, I just bomb out that night because I'm finished. It takes everything you have to sit there and to work through that and to resolve that mediation. So even if you don't resolve every single issue and the dispute, every issue you do resolve makes your litigation so much easier, because what is left is a very narrow, very limited issue for the court to decide. So there's nothing like we cannot mediate because it won't work. Parties who are very far apart in terms of conflict, and if there are very many issues in dispute, mediation can bring them closer, even if you don't close the deal. So if you are predictable, you are accountable, and you work with those parties, you engage everyone, you assess the risks and are very creative in creating those options for them to consider, then you demonstrate excellent, outstanding skills as mediators. And that's in our heart, in both your own and my heart. We would like to facilitate and assist people to get there, to be great. But remember, a baby crawls before a baby walks. So it takes time. It's not a skill you can acquire in your 40-hour foundational training. And mediators like myself, I'm first a mediator, then I'm an attorney, and way back there, I'm a litigator. It's a lifetime commitment at the end of the day. So I want to leave flexible resolutions with you and say to you that our doors are open. If you need assistance, please call on us. We're happy to assist. Thank you very much, host. That was my contribution today.
Charlene, thank you very, very much. I really appreciate your presentation. I think, it's important that we communicate, what's out there, and the various bodies that are available or that exist with regards to, the different areas of alternative dispute resolution, NEPFEM, SAM, etc., etc. There's also various bodies that provide training apart from the Law Society. I personally agree with you. The fact that we need to grow mediation, we need to grow alternative dispute resolution. I think as a representative from the Northwest-University, we offer these services at our law clinics, and I think from the applied legal studies that we teach in our final year to our final year LLB students, I stand to correction with regards to my colleagues at our law clinic and the applied legal studies module, that alternative dispute resolution definitely needs to feature much more, and we can only grow from there. Jonathan, is at a law clinic at his campus, and he tell you that I think we at the right place. We just need to find ways to grow this area of the law. Something that I just thought about when you spoke about medical legal. Just a silly example. The Department of Health has got so much litigation against them at the moment. They got bottomless pockets to litigate. They'll take forever to deal with matters. But if they just considered, entering into mediation, that resolve half of their backlog in such a short space of time. And there's a lot of work for us to do as mediators. I think there's just so much opportunity just out there. Thank you very much for your presentation. Colleagues, are there any questions or comments? Excuse me. Students who are present, you're welcome to ask Charlene questions about various institutions or training facilities available. I know that Charlene's involved personally with Johan, in developing different training modules and training in mediation. that's just, that's all I have to say at the moment.
Thank you, Andrew.
Thanks.
Thank you.
Seems like no questions for you, Charlene. I'm sure, oh, there we go. Mr. Tava, thank you. Welcome. Please go ahead, sir.
Thank you so much for the presentation, ma'am. And it just sparked a lot of interest. I'm actually very grateful for this whole colloquium because it's shed some light on, topics that you always just have in passing when you're sitting and thinking about how interesting ADR is as a means of justice and ensuring that justice is given to society at large. Now, my question to you is, post graduation of obtaining the LLB, there's always this murkiness around articles. Now, is it a necessity to first go serve your articles before now coming to your institutions that you've mentioned, who will then, I don't know if they then have their own rendition of articles, and how does that then go about? Or is it possible for me to then graduate and automatically after graduating go right into mediation? And like Mr. Kola did, there are certain training modules and the likes that you guys have. So how does that work? Could you kindly just shed some light on mediation as a line of employment?
So mediation in terms of the knowledge aspects, Africa, mediation theory per se is not complicated. Communication strategies might be challenging, and then you go to your skills. Now your skills, those have to be practiced. And you develop those skills with over time and as you get your cases in. But I would always tell young people to do articles or to go to the bar, because no learning is ever wasted. Any learning opportunity is valuable. And because we're walking this road of establishing mediation as a profession, to try and set up a mediation practice only, you may find yourself in difficulty. Even young attorneys, if they start practicing, and young advocates, it takes about 5 years to build a practice. It's not easy. So it's always better to go under the mentorship of somebody who's already got those skills and knowledge to make a contribution elsewhere. And then in that time to take courses and to do personal development. Take, for instance, emotional intelligence is incredibly important in dispute resolution based on interests. Because remember, litigation is clear and not clear. Because if you look at a rights-based litigation process, the law says there are certain requirements. You allege the requirement, then you bring the evidence and tick, tick, tick. And if you manage to do that, you can win a case. But in mediation, there are many soft skills, and one of those would be to be an active listener and to have a lot of emotional intelligence. Because remember, these parties in your presence, they have a lot of distrust of each other. They are fighting. So why should they trust each other? Why should they trust you? Take whatever learning you can and take every opportunity. And there are a lot of free resources also on the internet. And that's why if you start to just orientate yourself in terms of those websites I've given you of those organizations, that will guide you towards in what type of mediation you want to find yourself. I prefer medical legal because I've got a medical background. Johan he's very passionate about family law. I do a lot of family law with him, not because I love family law at all, because we want to serve. So I hope that makes sense. Thank you.
Thank you, ma'am. That really does shed some light indeed.
Charlene, thank you very, very much. Much appreciated.
Thank you.